Now, we have a few moments and I would like to invite people to ask some questions about learned speakers today. Would you like to, do we have a...
I don't need a microphone.
I think it's being recorded, so it might be easier. Perhaps could you introduce yourself before? Yep.
Hello, my name is Gunesh and I'm a Sydney JD student. My question will be about the personal life of the lawyers. A friend of mine who's a criminal defence barrister working for the New South Wales public defendants told me a story of himself defending a pedophile, and he won the case. And the plaintiff was actually a girl the same age with his daughter, and that actually affected him a lot. He started smoking and drinking, etc., and couldn't really get rid of this. Although it's been like 15, 20 years now. So in such a case, because of the adversarial system that we have in Australia, it's very possible that you can come across with an incompetent prosecutor, and you can win a case like that. And how would you overcome such a situation?
Would you like to answer first?
Well, yeah. I'll just quickly say that when I learned professional ethics, if you knew your client was guilty because they confessed to you, you could not run a not guilty argument. You just put the prosecution to the test. You couldn't actually run evidence that suggested no guilt because you knew that wasn't the case. This is the higher order responsibility to the court. But then, of course, everyone in our system does have an entitlement to a defence, even if that defence is really just about mitigation for what kind of punishment that they should have meted out. And so a solicitor in that case job would be simply to assist the client with those kinds of arguments. Or if the client wanted to run a not guilty plea, if they know that they are guilty, they should really recuse themselves from the case. So the idea that lawyers will run completely false arguments for people who they know are guilty, they definitely know are guilty, not just suspect is guilty, is actually a bit of a fiction of television
stories, yeah.
Of television to start with.
Yeah. I would agree. Yeah. Your example is really interesting. My daughter's 25 and she's a practicing lawyer. When she was about to be born, I visited a friend of mine, an academic colleague from UTS and then at Macquarie, whose husband was a public defender, one of the ones who are called upon to handle more serious cases. And so we were visiting his wife, who's expecting her first baby, who's actually a student at Sydney University doing her PhD. And he actually was called upon that day to defend a paedophile. Now, the difference is that he would not have actually properly asked, and it wasn't offered to know whether the guilt. So his position was very much, just as Joellen said, it's the right to have a defence, the right to be represented, and that was the priority. I can't speak beyond, the particular guilt and things, but I remember as a dad and a law professor going, oh my goodness, here you are to see your wife, and so we're in this position of just having a new baby, and that moral tension. You also mentioned the consequences, an area of work I've done a little bit in, but to do more, is the area of whistleblowers. So actually people who really are worried about their organisation and the various modes to go out and get protection. The research that has been done on whistleblowers who, in that sense, their moral compass is, we need to expose this, and we've gone through usually some other mechanisms, is appalling. The level of suicide, level of alcohol, drug abuse, etc., and that isolation that happens. And I think that's something that we probably do need. I think there's one of those, a bit like any legal dispute, there are mechanisms which you need to resolve before you jump straight to court. It's the same with whistleblowers. There are some things you should try to do, but there's a certain point where if an organisation is covering up and not taking it seriously, and I have a particular interest in the Commonwealth Bank at the moment, in the Royal Commission, and where you're seeing systematic abuses, where people are saying to senior management, this is going on, and it is totally ignored for profit. Whistleblowers whistleblowers are often one of the only ways, but the consequences of making that personal decision can be absolutely huge.
Yeah, Michael, following up on that question, it's one thing, of course, to talk about the ethical considerations in acting before the criminal defence, and that's well understood. But what about in the corporate sphere, representing a tobacco company, for example, whose product has deathly effects, and the tobacco companies have acted immorally for decades? Is there a moral issue there?
That's a great question, because and I think it's the sort of thing that in the teaching context we use our case studies. You know, an example, imagine you are, and take it away. I think, you know, while a product is legal, all right, so tobacco at the moment is allowed to be sold, then you have every right to represent. I mean, I'm also particularly interested in James Hardy and what they did with asbestos, etc. So that right to be, again, represented and to mitigate any damages, and the weekend I spent with some tax lawyers, and they're doing $80 billion type deals. And their line was, our job is to make sure the company pays the right amount of tax. They never talk about tax minimisation. They never talk about avoiding tax. Their job is simply to get them to pay the right amount of tax. So if you think about it, it's where you position yourself. But I actually came to academia because of exactly what you said. I worked for an in-house role in Europe in a major pharmaceutical company, and I believe my area was corporate intellectual property, and I felt they were going very close to thalidomide, and I had been caught up in thalidomide because of my age, and I had friends whose mother had taken the drug to remove the morning sickness, and they had various disabilities, so I had a heightened sense of that. And then to be the lawyer asked to do certain things with scientific evidence, to get certain patterns, knowing that it was wrong, actually facilitated a very easy decision to walk away. I wasn't going to change a global pharmaceutical company as a junior lawyer, but I was not going to be party to it. Like Joellen, I'm a practicing Christian at a church on the Northern Beaches, and then I was in London. My personal position was just not in line. Now, what was interesting is that, and this is where the true moral, when you start to dig and scratch away at what price will you do something, is that company had a foundation, an education support foundation. And I applied for a scholarship. I received that scholarship, so I was able to leave. And I said, I don't put in the same as a bribery or anything, but it was a competitive process, and that paid for my postgraduate studies. And I just found that I rather liked talking about the law and that part, and so I made that sideways move. But the trigger, without doubt, was being asked to do some things that I knew weren't appropriate.
So we have maybe one more. Yes?
Thanks very much for both of you for your presentations. I was particularly interested in Joellen's comments about the need to teach people to listen to both sides of arguments. It seems to be an aspect of society which is disappearing. I think that's a lot to do with technology, because nowadays you can actually live entirely, and it's very tempting to do, in a bubble where you only ever hear from people with whom you agree, so you never actually are exposed to even the idea that there is another perspective. But I just wondered where in the law program that particular skill, in relation to emotional issues in particular, might be taught, and if it is being taught at Western Sydney or Sydney, how it's being taught and how effectively it might be being taught.
I'm tempted to answer that.
Well, by all means do, Mary, yeah.
I'm an administrative lawyer, and so I teach procedural fairness, and I am very firm with my students in telling them that what we're going to learn in terms of the principle of listening to both sides is a life lesson, not just a legal process. And I say to them, this is the most important class you're ever going to do at law school, because from now on, whenever you hear somebody say something nasty about your friend on Facebook, you should respond as a lawyer to say, that's adverse information, it's come from someone I don't know, I must test it with my friend. I find, I'm interested to hear your views on this too, but I do find that when you go into an administrative process, and very often you get appeal bodies, I actually sit on the Student Appeals Board, for example, and you're sitting alongside people who haven't studied law, and very often they don't have that sense. I think we're born with it. In fact, I say this to my class. I say, when you're born, you know that if somebody doesn't listen to you as a child, it's not fair. If someone takes your things and you're not allowed to talk about it and say things, you understand that's not fair. Something happens as we grow up, as we begin to assume power, where we unlearn a lot of those basics principles of practice. So I would like to think that at Sydney University, certainly in the subjects, there are a number of subjects though where we teach that, from ethics, from administrative law, any of them. I repeat that in all the courses that I teach, to be honest. And in my lived experience also is that I think that lawyers do come out with that innate understanding. That sounds like nasty stuff. I've got to test it. I've got to look at both sides.
Yeah, I agree with you, Mary, and obviously the administrative law areas really, not only do they do that, but they draw to the surface that those are the principles that are being applied. But I think that if you teach law in a way that really encourages students to read the cases themselves and to read the whole of the case, then they'll get accustomed to reading. That won't just be a few principles from a textbook that they learn to use like an algorithm or a formula, but they'll see the process of reasoning and they'll see the gathering of the evidence, particularly if you ask them to read not just appellate decisions but some first instance decisions. They'll read the assessment of credibility of certain evidence. They'll hear through reading the delivery of the evidence the different perspectives on a particular story and what was tested as being provable and what wasn't. And often, once they do get to appellate judgments, they'll also see that you can in our High Court, you can occasionally have a split 4-3 decision where nearly everyone has written their own decision that comes from a bit different perspective. And the thing that I say to students is, see how our system works. It actually takes into account multiple viewpoints, and it's always very difficult to know exactly what the right answer is. What is the right answer depends very much on the viewpoint that you've allowed to dominate, and we can see that by reading High Court judgments sometimes. So I would say that the way we teach it is, yes, bring it to the surface as a set of principles in administrative law type subjects, but also in the methods we use to teach all law subjects to focus on the whole process of legal reasoning by looking at the cases themselves.
Yeah, we'd be very similar. In Western Sydney, we have, as a lot of universities, called graduate attributes. In other words, by the end of the degree, you should achieve these things, and one of them, of course, is around being a good global citizen and the ethical part with that. And so we also integrate it. It does come up in our jurisprudential type courses. So we have a legal philosophy and critique type subject, etc., where it's more explicit. I mean, what part of the issue here is sometimes, just like Mary said, it may be taught, but sometimes students actually categorise like, this is this box, this is what I'm learning, and they actually don't always put the dots together. Sometimes we have to sort of signal, actually, and my example about the Ford Pinto one, it comes from a corporate law context to actually say, corporations can do some really bad things, and one of the questions is it the fish rotting from the head? In other words, is it the CEO driving for profits, etc., or is it somebody down the chain, or is it the big debate in corporate at the moment is corporate culture. What does that mean? How do we control it? And all the regulators are shouting and screaming. I also wanted to pick up that, I'm looking at my colleague here from UTS, we actually share the same lecturer to teach Islamic law, so we have a Foundations of Sharia law, but both our institutions. We also teach, we haven't had the media come on to us, which is interesting, well, we teach Foundations of Chinese law, Foundations of Indian law, and we use what's called the New Colombo Plan, so they do some of it here, and then they fly to a sister relationship university in those other countries. And surely, and then we have obviously a comparative law subject. Isn't that part of education, to understand our differences? And so, again, we would obviously fully support and Sydney's to have those processes. And the banking and finance stuff is absolutely critical to understand in this complex world. So yes, we think that's significantly important, but we do it as well.
Yeah, and one of the things we did with the Daily Telegraph was give them a list of all the great universities around the world who had similar programs, including Harvard, Oxford and Cambridge. They didn't think that Sydney students should get as good an education as that. I can't understand what their concerns were. But, look, why does the Daily Telegraph pick on the University of Sydney?